Morning, everybody. My name is Colin Archibald. I'm a partner in the Commercial Disputes and Regulation team here at Shepherd and Wedderburn, and I head up our property dispute resolution group. And a number of you may have attended our in-person seminars that we've run over a number of years, and over the last year or so we have gone online. And so a very warm welcome to all of you to this morning's session on issues around the termination of commercial leases and dilapidations. And I'll be talking about some recent case law in relation to lease termination in a couple of minutes. And then Dan Bain, one of the senior associates in the team, will be talking about dilapidations. The session is scheduled, we've actually got a little bit over an hour in the diary, so we should have plenty of time for questions at the end. I should also mention in advance that for those of you that received the flyer, it had originally been scheduled to be myself, Dan, and Steph Hepburn from the PDRD team. Unfortunately, Steph has been struck down with a very bad cold. Delighted to confirm it's not COVID, but she has lost her voice, which is obviously not all that useful for the purposes of delivering a seminar. So anyway, it's Dan and it's me. And a very warm welcome to you all. As I mentioned, we are very happy to take questions at the end, and thank you to those of you who've asked some questions in advance. You can, through the Q&A box, answer or ask rather additional questions as you go along, and we'll pick them up a little bit later on, so far as we've got time to do so. Without further ado, I have a slight technical challenge to make sure that I share my screen, and I will do that to set up the slides for the talk I'm about to give in relation to tacit relocation and the recent case of Rockford Trilogy against NCR Limited. Okay, the technical challenges have hopefully been cleared, but as I say, I am going to speak this morning about the recent decisions of the Court of Session in relation to the Rockford Trilogy against NCR case, looking at the Scots law of tacit relocation. And thank you, I mentioned the questions already, and thank you at the outset to one of the attendees this morning who asked a question in advance as to whether or not the Rockford Trilogy decision is a game changer. I won't do any spoilers, I'll come back to that question at the end, but wanted to start by talking about what tacit relocation is all about. So, what is tacit relocation? The term tacit relocation should be familiar, I think, to many of you in the audience who are involved in commercial leasing, but for those for whom the term is a new one, I'll just give a little bit of an explanation of what this is all about. Now, despite having a lease termination date, or an ish, as it's often referred to in Scots law, tacit relocation requires that clear notification of an intention to vacate let premises must still be given by either the landlord or the tenant before the termination of a lease. If no notification is given by either party, the lease is deemed to continue for a further year. On the face of it, that might seem a little bit strange. How is it that on the termination date of the lease, even if no notice to quit has been given, the tenant cannot simply close up its premises, remove its stock, business kit, whatever it might be, and move out? And on the other side of the coin, why can't the landlord arrive at the premises the day after the ish and expect to find the property vacant, ready to re-let it to a new tenant, in an ideal world, of course? The answer is that by operation of the law, the doctrine of tacit relocation applies to determine that as a result of the silence of the parties regarding termination, the lease is to continue. In those circumstances, and in the absence of express written provision to the contrary, a termination date in a lease might be seen as more of a mutual option to terminate rather than a hard deadline that will definitely bring the contract of lease to an end. And I've mentioned on the slide the fact that this whole question of notice and how it's usually given. If you want to avoid tacit relocation applying, it's important that the necessary notice is given before a lease expires. So generally, for commercial leases longer than a year, at least 40 days notice has to be given. There are peculiarities around that, but I'm not going to go into all of that detail today. But with that said, a lease does sometimes contain provisions for serving notices which can displace that standard 40-day rule. Additionally, a lease will often contain provisions about the form of any written notice, that it has to be by letter, that it might have to be served by recorded delivery, and that sort of thing in order for it to be valid. The key point is that what is needed is evidence of sufficient notice having been given of an intention not to prolong the lease. And the usual method of doing that is by giving a written notice to quit, by serving a formal letter known as a notice to quit, which usually follows a prescribed form that complies with the requirements of some very old legislation, the Sheriff Course Scotland Act from 1907. And we'll come back very briefly to mention that old and horrendously complex piece of legislation at the end. However, it is also the case that verbal or informal written notice can exclude the operation of tacit relocation. The cases talk about explicit or overt intimation to that effect, and it is that issue of whether informal notice sufficient to exclude operation of tacit relocation had been given that the Rockford decision considered and was ultimately decided upon. Now, some of you might be familiar with the premises. I'm sure most of you will be familiar with Eurocentral, and there's a little photo on the next slide of the building where the premises in question are located, can be found just off the M8. The couple of details that are particularly worthy of note are that the lease term was to run till the 26th of March 2020, which would mean that if a formal written notice to quit was to be given, then the last date for effective service of that would have been the 14th of February 2020. And so in terms of everything that gave rise to the litigation is concerned, from around June 2019, the landlords and tenants agents entered into lease renewal negotiations, which ultimately failed. Meantime, the notice to quit deadline of the 14th of February 2020 had passed without a formal notice to quit having been given. NCR then vacated the property in March 2020 as they considered the lease to be at an end, but Rockford raised an action in the Court of Session seeking an order from the court that the lease hadn't in fact terminated, as tacit relocation had operated to continue it for a further year. If right, this would mean the NCR would be liable for a further year's rent, service charge and insurance, which was likely to run to a significant amount of money. So we have the battle lines drawn, the court proceedings raised, and the issues that crystallised in the litigation. The position on the part of Rockford that the lease hadn't terminated, as no formal notice to quit had been given, that tacit relocation applied, so that the lease continued until at least March 2021. Tacit relocation can operate year on year, and Dan and I have certainly seen a number of leases over the piece where they've run on for years after the original issue. And the key point I've already touched on of the financial consequences, if their argument was right, about liability for a further year's rent and other charges. On the other side of the fence, NCR's position that informal notice sufficient to displace the operation of tacit relocation had been given, so that the lease had in fact ended in March 2020. And as a consequence of all of that, they asserted NCR was entitled to quit the premises at the end of March last year. So what did the court decide? I mentioned in one of the earlier slides the informal negotiations that had started in June 2019 and had run through into the early part of 2020. And the key email that was founded upon in support of the NCR position is the one that I've quoted next. This is a slide, a quote that the only way, it was said in this email from JLL to Savills on the 21st of January 2020, that NCR would consent to remaining at the building as if the dilapidations are capped at £300,000 together with nil rent for 12 months. So a clear statement of a couple of conditions that NCR sought to argue made clear what would be required if they were going to be willing to stay. And to the court, this was sufficient to put the landlord on notice that NCR intended to quit the premises at the end of the lease unless those specific demands were met. As a result, tacit relocation wouldn't apply. In reaching his decision, Lord Clark summarised some of the case law and stressed that tacit relocation only applies where there is silence on the issue of renewal. Informal notice, even within an email dealing with a number of other matters, can be sufficient to exclude application of tacit relocation. A word of warning, and we'll again come back to some of the lessons that we might learn from this at the end, was the point that simply discussing the question of renewal in itself, in general, is unlikely to prevent the operation of tacit relocation. The court noted that previous decisions have recognised agents or parties could engage in meetings, discussions, for whatever form of informal conversations about a question of renewal without any effect on the application of tacit relocation. It's only where there is this overt intimation that the landlord or tenant doesn't consent to tacit relocation that it won't apply. And here, Lord Clark concluded that NCR's position, as set out in the January 2020 email, was sufficiently clear and overt to exclude the operation of tacit. It set out in plain terms, in the eyes of the court, an unequivocal intention on the part of NCR to terminate the lease unless two specific conditions were met. They weren't met, and so the operation of tacit relocation was found to be excluded as a result. As many of you may know, though, that was not the end of the saga, because the decision of Lord Clark from earlier this year was appealed to the inner house of the Court of Session, and very conveniently, from our point of view, the inner house issued its decision a couple of weeks ago. So this is a relatively recent update on the position, and the long and the short of it is that the appeal was unsuccessful. But just to touch on some of the detail around that first of all, Rockford sought to appeal Lord Clark's decision on the grounds that he didn't consider the January 2020 correspondence in its proper context, bearing in mind what else was being discussed in the broader negotiations. And it was also argued on behalf of Rockford that the inclusion of standard wording in Rockford's agent's email footer, that the email didn't form part of any legally binding contract, might also exclude the operation of tacit relocation. But both of these points were rejected, and the court upheld Lord Clark's first instance decision. Now, the key passage from the inner house's judgment in that respect I've put up on the screen for you. What they said was that the commercial judge was correct to interpret the January 2020 email as providing sufficient intimation that NCR would not continue under the lease on its current terms. That was inconsistent with implied consent to the prolongation of the lease and was enough to exclude the operation of tacit relocation. The reclaiming motion, i.e. the appeal, must therefore be refused. The Inner House, in short, found that Lord Clark was correct to conclude that NCR had stated sufficiently clearly that the lease wouldn't automatically renew, and to find that tacit wouldn't operate. And there was no merit, the court found, in the arguments around the details of the email footers that were relied upon in support of Rockford's appeal grounds. So, a cautionary tale. I think it's probably fair to say that the Rockford decision does clarify that informal notice is possible in order to displace the operation of tacit relocation, but, and it is an important but, that's only where it's made sufficiently clear that consent to the operation of tacit relocation has been excluded. With that in mind, using a formal notice to quit will avoid any ambiguity and state a party's positions in the clearest possible terms to avoid the sorts of arguments that needed to be had in this case. A broader thing, and it's one that is probably sometimes quite difficult to give any general statement, other than always to be very careful about how you frame, whether it's verbal discussions or it's written correspondence, so that you think about what it is that is being committed to writing or what is being discussed, to try and avoid serving up hostages to fortune earlier down the line, inadvertently getting yourself into a position where a position is adopted or a concession is given or so forth that might be made in all good faith at a particular point in time, but further down the line might be unhelpful to a particular negotiating position. And the one other way of trying to reduce the room for argument here is the fact that, as I touched on, using a formal notice to quit to try and avoid any ambiguity. One thing that can often happen, and Shepherd and Wedderburn standard form leases provide for this, they make express provision for it being necessary to give formal written notice meeting certain criteria in order for a lease to be brought to an end. So it's absolutely crystal clear what needs to be done if a lease is to be terminated at its ish. And so it won't, in those circumstances, it's highly unlikely to be possible to rely on informal notification where there's an express provision of the lease. And finally, from me, as far as the substance of the discussion is concerned, just to mention the fact that there is the prospect of reform of the law in this area. I mentioned earlier on the Sheriff Courts Scotland Act from 1907. As with many very old statutes, it's a pretty horrendous piece of legislation. It's pretty difficult to navigate and very good at serving up pitfalls for the unwary. And that is one of the reasons why the Scottish Law Commission has been looking at this broader area. It's looking at a broader reform and modernisation of the law on the termination of leases generally, in relation to notices to quit, the possibility of parties being able to contract out of the operation of tacit relocation and so forth. And as you'll see, there is a consultation process likely to be coming down the tracks in a few months' time. And so if it's an area of the law that you're interested in, if you have views that you would like to share as part of the consultation exercise to feed into the draft bill that's already a work in progress, I would encourage you to get involved in that. And the final thing for me is to come back to what I mentioned at the start and to answer the question as to whether or not the Rockford decisions have been a game changer. I think the short answer to that question is No, because they haven't really changed anything, but they are rather a restatement of the position with regard to what needs to be done to prevent the prolongation of a lease by operation of tacit relocation. This can be prevented by means of informal notice. That's not new. And the Rockford decision is a helpful and high-profile reminder of that. It also gives some helpful up-to-date guidance on what is required in that regard, whilst underlining that best practice will always be to provide formal notification of the termination of a lease by means of a notice to quit. Otherwise, you're going to be straight into the territory of arguing about the facts and what they mean so far as the application of the law is concerned, and the consequent uncertainty and expense that will have affected the parties to the Rockford dispute. So that's all from me. I will pass over to Dan now to talk about a range of issues in relation to dilapidations, but as already mentioned, I'll be very happy to pick up any further questions on this topic at the end. Thanks very much.
Thanks, Colin. I will now my slides up on the screen. Now, hopefully you can all see that. So continuing the end of lease theme, I'm going to look at well, one of the main issues that parties to a commercial lease have to grapple with at lease termination, which is the topic of dilapidations. But I'm going to focus in particular on quantification of the claim and some of the issues that can arise. And in particular, I'm going to look at a recent reported decision, which for the first time in Scotland looked at the question of certification in the context of a payment clause for dilapidations, and in particular looking at the scope of the certificate and the question of whether it was binding. But before coming on to that, I'll have a quick sort of run through some of the key things to bear in mind when quantifying a dilapidations claim, and what the landlord's main remedies are and when they might apply. So firstly, what are the landlord's remedies after termination of the lease? Well, normally it's one of two. The first being damages for breach of contract. That's a common law remedy. It's available in the absence of express provision in the lease for another remedy. It's essentially to compensate the landlord for loss suffered as a result of the tenant's breach of contract, the breach of the repairing obligations. The other remedy that might be available to a landlord is payment. Now, both damages and payment involve payment of a sum of money by the tenant to the landlord, but the difference between the two is that payment, if there is a payment clause in the lease, entitles the landlord to demand payment of a sum of money, which will be quantified in accordance with the lease provisions, regardless of whether loss is suffered. So that's a key difference. There's an advantage to the landlord there if there is a payment clause. So we'll come on to look at that topic in a few moments. Specific implement, it might be available. It isn't normally available. It's unusual because it depends very much on what the lease provides. It's certainly a remedy that a landlord can use during the currency of the lease if the tenant is failing to comply with its repairing obligations, although it's unusual for a landlord to look to try and enforce repairing obligations during the term of a lease, but certainly that's something that's possible. But after lease expiry, it's not normally possible for a landlord to essentially force the tenant to come back and carry out the repairs that the tenant ought to have carried out before termination. There is case law to the effect that is the case unless there is an express provision in the lease that provides otherwise. For example, a provision obliging the tenant to carry out certain works at termination, after termination, or entitling the landlord to require the tenant to come back within a certain period of time. You do see it from time to time, so it's always worth checking whether that's something that's available to the landlord. But as I say, it's not something that is normally available. So looking first at damages and some of the sort of key things to bear in mind. As I've mentioned, damages, it's essentially payment by way of compensation for losses suffered by the landlord as a result of the tenant's breach of contract, the breach of the repairing obligations the tenant was under during the term of the lease. Now, there are a number of different ways in which the claim can be quantified. The usual basis is obviously that is for the landlord to quantify the claim on the basis of the cost of works required to put the premises into the condition that they should have been in if the tenant had complied with its repairing obligations. So, the landlord will obviously then have a surveyor draw up a schedule of dilapidations and cost the works that are required. But that isn't always the way in which a dilapidations claim is quantified. And example there on the slide, if the landlord, fairly swiftly sells the property after termination, but the price is lower than it would have been if the tenant had left the premises in the condition they should have been in, well, then in that case, diminution in value is going to be the more appropriate basis for quantifying the claim rather than the cost of works, because it's clear then that the landlord, having sold the property, is not going to carry out the works. So it's then the difference in value between the price that the landlord would have achieved if the tenant had complied with its repairing obligations versus what the sale price that was actually achieved. So, as I say, the normal basis for quantifying the claim is the cost of works, but depending on the circumstances, that might not be the most appropriate basis. So it's always advisable to consider what the basis should be. Now, unlike in England, there is no statutory limit on the damages claimed in Scotland. So as many of you will know, in England, the Landlord and Tenant Act 1927 provides that essentially a damages claim for dilapidations can't exceed essentially the damage to the landlord's reversionary interest, that diminution in value. So it's capped at the diminution in value resulting from the dilapidations. So that might mean that actually the landlord can't claim the full cost of repairs because that exceeds what our difference is. Now, we don't have that in Scotland. There is no statutory cap. The landlord, it's open to the landlord to quantify the claim in whatever way they consider to be appropriate. But equally, it's open to the tenant to argue that the measure of loss that the landlord has used is not the appropriate measure of loss on the circumstances. So again, in the same way that it's always advisable for a landlord to consider what the appropriate measure of loss is, a tenant should also consider whether the right measure of loss has been used, and it may be possible to argue that that actually something different should be used. There is generally, it's worth bearing this in mind, if you're connecting for either party, a sort of duty on the landlord to mitigate loss. Although it's referred to as a duty to mitigate loss, it's not a duty as such. There's no obligation on the landlord to do that. But what it means in practice is that the landlord cannot claim the landlord's required to take reasonable steps to mitigate the loss suffered as a result of the tenant's breach, and the landlord cannot claim any losses that would not have been suffered if they had taken reasonable steps. So if there's a failure to take reasonable steps, then the tenant can argue that certain losses may not have been suffered if they had done that. Now, it is for the landlord to establish that if the landlord considers that reasonable steps haven't been taken, then it's for the tenant to to make that argument and seek to establish that the reasonable steps haven't been taken. So it's always something to bear in mind. If you're the landlord, keep in mind that you do need to take those reasonable steps. Otherwise, you might be facing an argument that that some of your loss is irrecoverable. And if you're the tenant, always worth considering whether the landlord has in fact taken reasonable steps to mitigate. Now, in making the claim, and again, coming back to that principle that damages are compensation for loss, the landlord must establish that the tenant's breach has caused loss. So there has to be a sort of causal link between the tenant's breach and what's being claimed. But that doesn't mean that the landlord has to have carried out the works before claiming damages. If the claim is based on the cost of works, then the landlord can claim the cost that will be incurred in carrying out the works before the works have been carried out, unless the lease provides otherwise. In a moment, we'll look at an example of a case in which the tenant tried to argue that the landlord did have to carry out works before making the claim for damages. In certain circumstances, a tenant might have a no loss defence. So it's always worth, if you're a tenant, it's always important to consider whether the loss that the landlord is claiming has in fact, will in fact be caused or will in fact be suffered, has been suffered. And sort of main examples of that would be if there's evidence that the landlord actually intends to demolish or redevelop the premises in such a way that the repairs that the tenant was obliged to carry out are essentially redundant, will be superseded. In those circumstances, it's open to a tenant to argue that all or at least some of the losses claimed by the landlord are not in fact losses, that loss hasn't been or will not be suffered. Those are the key examples. It's always open to, there may be, evidence to suggest the landlord just has no intention of carrying out the works. So, again, it's always an argument that a tenant might make, but unless there is that evidence, to suggest that, then, it might be difficult to establish. So it's always something that's going to depend on the circumstances, but always important to consider. Loss of rent worth mentioning, that is a legitimate head of claim and a dilapidations claim, but it might be difficult to establish unless the lease expressly provides for that. A lot of leases do. A lot of leases will expressly say that in the event of dilapidations, that the tenant is required to pay the rent that was payable under the lease for a particular period of time post termination. Generally speaking, that sort of clause is enforceable, but in the absence of anything like that, whether or not loss of rent can be claimed is going to be, again, something that's always going to be dependent on the circumstances, and market conditions are going to be key. So if, for example, regardless of the dilapidations, the landlord was unlikely to be able to re-let the premises for a significant period of time because of market conditions, then the loss of rent is not something that's been caused by the tenant's breach there, and it's going to be very, very difficult for the landlord to make a loss of rent claim. So again, always something that's worth the parties considering, but just a sort of word of caution that might be difficult to establish depending on the circumstances. So I mentioned a few moments ago an example of a case where a tenant had tried to argue that the landlord was required to carry out works before making a claim for damages. That was Moore against DWF back in 2017, which some of you might be aware of. Again, it was a tenant looking at the particular lease provisions and saying, well, on the basis of an interpretation of this lease, there's the landlord couldn't make the claim without having carried out the works first. The court, however, disagreed with that, concluded that the lease did not require the landlord to carry out the works before making the claim. Essentially, what the court said was that if the parties had agreed that, then the court would have expected clearer wording to that effect. So the case essentially reaffirmed, the position that has long been the position in Scots law, that in the absence of express terms to the contrary, a landlord is entitled to quantify the dilapidations claim by reference to what it will cost to carry out works which the tenant failed to carry out. But it's open to the tenant to seek to prove that the landlord will suffer no loss, or that the loss is materially less than the sum claimed by the landlord. If that is not the case, then you would expect to see pretty clear provisions in the lease to the contrary of that. So unless there is that clear wording, then it's likely that that long-established common law position will apply. Now, I mentioned damages is not the only possibility at lease termination. If the lease contains a so-called payment clause, then the landlord can, and as we'll come on to see, it may be that this is the landlord's only remedy, but the landlord can claim payment of a sum quantified in accordance with the lease, and there's then no need for the landlord to establish loss. Now, this was established really back in 2015 in the case of ATSIP pension trustees against Insight Travel Services. Many of you will remember there were a run of cases leading up to the appeal decision in that case, where landlords had argued that the leases had contained payment clauses, but the court had disagreed, essentially holding that the clauses in question were a restatement of the common law position and that they provided for damages to be payable. But then we got to the appeal decision in ATSIP pension trustees, and in that case, the appeal court determined that on a proper interpretation of the lease provision, in particular the provision that's up on the slide there, it required essentially payment of a sum of money. It's the wording in bold that's the key wording there. The tenant was required to pay to the landlord at the determination date a sum equal to the amount required to put the lease subjects into good and substantial repair. So, the court concluded that the natural and ordinary meaning of the clause was that it was a payment clause. They said the words clearly indicate the parties intended that if the subjects were not at termination in the condition in which they would have been if the tenant had complied with its repairing obligations, then the landlord was to be entitled to payment of a sum equal to the cost of bringing them up to that standard. So the question of whether the landlord intended to carry out the works was irrelevant. So always very important to check in reviewing the lease provisions whether there is a payment clause, because if you're the landlord, that's going to make things considerably easier for you. ATSIP was followed a year later by Tonsley 2 trustees against Scottish Enterprise, and the relevant clause from that case is up on the screen there. So essentially, the clause there provided an option to the landlord that the tenant carries out the works necessary to put premises in such the necessary repairing condition, or that the tenant shall pay to the landlord the sum certified by the landlord as being equal to the cost of carrying out such work. The tenant in that case attempted to argue that was not a payment clause, but unsuccessfully. The court followed ATSIP in concluding that that clause was a payment clause, not a damages clause. The court said that the ordinary and natural meaning of the clause is that it provides the landlord with the option of certifying a sum equal to the cost of the works necessary to put the premises into the condition in which they ought to have been at termination had the tenant duly performed its obligations under the lease. And in fact, the court came to the view that the clause was actually quite similar to the clause in ATSIP. So again, as with ATSIP, the landlord was entitled to seek payment regardless of whether they intended to carry out the works. Now, you'll see in the clause there that it provided for certification, and one of the issues in the case, alongside the issue of whether or not the payment clause was in fact a payment clause, was whether the requirements of certification had been met. The landlord was relying on essentially a revised schedule of dilapidations that had been intimated to the tenant along with a cover letter. And their position was, well, the certification was made in that schedule of dilapidations in the cover letter, or alternatively, the certification was affected by the raising of the court action, which was based on the schedule of dilapidations and cover letter. And what the tenant argued was that, well, certification required a definitive statement of what was certified, and not just notification of a claim. They said what the landlord was essentially arguing was that notifying the claim was sufficient. And the tenant was saying, well, look, in the circumstances, the requirements of certification haven't been met. There has not yet been a valid certificate. Now, the court came to the conclusion that the schedule of dilapidations and cover letter that the landlord was relying on could constitute certification, but the issue could be decided without giving evidence, so there needed to be a proof, and in the end, there wasn't a proof. Presumably it was settled before it got to that stage. So we didn't get a definitive decision on that point. The court did make some general comments that about certification, which are worth bearing in mind. Firstly, what constitutes certifying a certificate is dependent on commercial or legal context in which the certification clause appears. Generally, unless the contract provides otherwise, the certificate doesn't need to be in any particular form. And of course, it's not necessarily a prerequisite of a certificate that it be final and conclusive. But these, as I say, that there wasn't a definitive decision on the point, because the court came to the view that evidence needed to be led before it could come to a definitive decision on the point. But these comments are worth bearing in mind. So the issue about certification in that case was very much around the question of whether or not there had been certification. There wasn't, the parties didn't get into, and the case didn't really discuss, I think, what in some ways is just as important an issue about, well, what's the scope of the certificate, what can be certified, and actually is it binding on the parties? And until earlier this year, there wasn't really any case law on that in Scotland in the context of a dilapidations claim. And the case that I mentioned earlier is your coal pension properties against Technip UK. It's really the first time in a reported decision the court has looked at the issue of certification in a bit more detail. Now, the clause in question here is clause 17.1 in the lease, and 17.1, had the usual obligation on the tenant to return the premises in the condition in a condition that met compliance with its repairing obligations, and then went on to provide that if at the end of the term property wasn't in the state of repairing condition required by the lease, then the landlord had an option either to require the tenant to carry out at its own cost the works necessary to put premises to put the property into that repair condition, or to require the tenant to pay to the landlord the reasonable sum certified by the landlord's surveyor as being equal to the cost of carrying out such work. And then, if that's paid within 20 working days, then the landlords must accept that in full satisfaction of the tenant's liability under clause 17.1. There was also a provision that if the tenant didn't comply with its obligations under clause 17.1, then the tenant had to pay to the landlord an amount reasonably equivalent to the annual rent at the rate payable immediately before the end of the term, portioned pro rata. That was quite an important provision in determining the certification issues, and we'll come on to see that. So the main question really was, or one of the kind of key issues was whether certification covered only the valuation of the required repair works, which the tenant was arguing, or whether it extended also to determination of what repair works were required. And the court eventually preferred the landlord's interpretation that certification extended to determination of what repair works were required. And the fact that clause there, the fact that the tenant, if it didn't comply with its obligations, had to then pay essentially a loss of rent, was an important consideration for the court. It described it as an incentive afforded to the tenant. That any liability for lost rent could be discharged by making payment of the sum certified for repair works within 20 days. And what the court said was that this incentive would make no commercial sense if disputes as to what works were required were excluded from the scope of the surveyor's certification and reserved for determination by the court. That would mean that the 20-day period for payment of the certified repair costs wouldn't begin to run until after any such court proceedings had come to an end. And so then the purpose of the incentive to pay the certified sum promptly within 28 days and thereby to allow the repair works to proceed and the rent loss to be minimised would be defeated. The court also took the view that the inclusion of the word reasonable was significant. So the parties to the lease have envisaged that only a reasonable certification will start the running of that 20-day period for payment of repair costs. So the court commented that the clause doesn't provide that whatever sum is certified by the surveyor must be taken to be reasonable. It provides rather that the sum has to be reasonable, i.e. within the reasonable range of sums that might be arrived at by a surveyor acting in good faith and exercising professional skill. So looking at the particular words of this clause in this lease, the court came to the view that essentially the landlord surveyor could certify not just the costs, but the question of what repair works are required. And that was significant because there appeared to be quite a significant dispute between the parties about what was actually required in terms of the tenant's repairing obligations. The other key issue considered by the court was whether the sum certified was binding on the parties, and the court said that it was. That is what the clause provided for. Otherwise, the clause said the clause would serve no purpose. It was certification that created the landlord's entitlement to payment and the tenant's obligation to pay. That's what triggered it. So, there would be no purpose if it wasn't binding. Now, it's worth mentioning here that the landlord, in making the court action, claimed damages as an alternative to payment. Now, there was, I guess, similar to Antonio, there was a dispute about whether or not valid certification had been made. And essentially, the issue there was that in the sort of certified schedule of dilapidations that was issued, the total certified sum included the loss of rent. But as we've seen, what the clause provided was, this incentive, as the court put it, that if the tenant paid certified repair costs and fees within the 20-day period provided for in the clause, then the loss of rent wouldn't be payable. The loss of rent only became payable if the tenant failed to comply with their obligation under the earlier clause. So what the landlord did is say, well, if we think valid certification has been made, but if we're wrong about that, well, here's our alternative claim for damages at common law. Now, in the end, the court came to the view that there had been a valid certificate. It did comment that it was unfortunate that the landlord had certified a total sum that included the loss of rent, because that wasn't correct. The certification, the schedule of dilapidations, the letter that was issued, didn't take account of the 20-day payment period in the clause, so it didn't totally reflect the mechanism in the lease. But notwithstanding that, the court said, well, it was clear. It's clear from the schedule what constitutes the repair costs certified, what is the loss of rent. So it's clear to it ought to be clear to the tenant what was being claimed by way of payment in terms of the clause. So ultimately, the court came to view that there had been a valid certificate. But if there hadn't, what the court said was that it wasn't possible for the landlord to claim damages as an alternative. The court took the view that the clause 17.1 provided an exhaustive remedy for the landlord in the event of a breach of the tenant's repairing obligations. Commented that the remedies provided in that clause are not the same as the landlord's remedies in common law, and that it would make no commercial sense to interpret the lease as conferring on the landlord an option either to exercise its contractual remedies or to ignore them and sue for damages in common law instead. So yeah, I think that's an important thing to bear in mind. If the lease provides for a remedy for the landlord, payment, certification, then it's likely to be the case that that is exhaustive and will mean that the landlord doesn't then have a claim at common law. But it's something that's always going to depend on the terms of the lease. And equally, the two key issues in this case around the scope of the certificate and what it could cover, and the question of whether a certificate was binding. Again, I think it's worth emphasising those issues are always going to depend on an interpretation of the particular wording of the lease in question. I suppose it's not really clear. Mentioned this incentive, as the court saw it, this incentive that if the tenant paid the certified repair costs within 20 days, then there wouldn't then be a requirement to pay loss of rent. That was a key consideration for the court in determining that that the certificate could extend to what repair works were required, and that it was binding on the parties. The reasonableness requirement was a sort of provided some comfort, and that it was open to to the tenant to argue, well, no reasonable surveyor would include that cost or would quantify it in that way. That was an avenue of challenge that was available, but the avenues of challenge were limited, and that incentive that was there, as the court saw it, seemed to be a key consideration. So it's not clear on the basis of this case whether that wasn't there, would it have been binding? Would it still have had the certification have had the same scope? Possibly, but it's always going to depend on the particular lease terms. So I suspect this is maybe not the first, maybe not the last case we'll see involving certification in the context of a payment clause, and it will be interesting to see where that goes. So that was all from me, and I think we can turn now to look at some questions if people have submitted any.
Thanks very much, Dan. Well, thank you both to the people that submitted questions in advance, and we've had a few questions coming through over the last 45 minutes or so whilst Dan and I have been talking. So I wonder whether we could try and pick up as many of them as we can in the next few minutes. There was, it's possibly a follow-on, Dan, from what you've just been talking about, a question that's come through in the course of the discussion about diminution in value. It's my understanding that whilst it is open to the tenant to contest diminution in value, this hasn't been challenged successfully in a Scottish court. Is that correct?
Yes, essentially. I mean, there isn't yet a reported decision where a tenant has successfully argued that diminution value is the appropriate measure rather than cost of repairs. But it's not something that the courts have ever ruled out. In fact, I think the case law is clear that it is open to a tenant to make that argument. I mean, it's something that is it's always going to depend on the circumstances as to whether that is the appropriate measure or not. So yes, that is right, but it's still something it's worth bearing in mind. It's something that can be argued.
Yeah. One thing, Dan, I wondered whether it was worth reiterating as well in relation to that is that, well, put payment clauses to one side because that perhaps slightly skews the picture. But if we were talking about a good old-fashioned repairing obligation where your primary remedy, as you've explained, is damages for breach of contract measured by reference to the cost of doing the works. It is, as the questioner asks, open to the tenant to argue that diminution in value is the appropriate remedy in the circumstances, but what that's likely to require the tenant to do is to offer to prove to the tribunal that the landlord doesn't have any intention of doing these works.
Yeah.
So the primary remedy, the primary measure, the cost of the works, is displaced, and then you turn to looking at what that diminution in value might actually be. And then, so far as the answer to the question is concerned, you have already given it. There is no law, there's no case authority on that point. But as a matter of principle, it is open to a tenant, subject to satisfying the relevance criteria.
Yeah, yeah.
And there was another one, I think, for you that was submitted in advance, which, if I just scroll up, excuse me, find it from the note I got in advance. Yeah. Can the total dilapidation sum exceed the landlord's loss, and if so, in what circumstances? Now, you've probably covered this in a fashion already, but maybe just to draw those strands together.
Yeah, well, essentially, I mean, in principle, no, because damages are to compensate the landlord for loss suffered. But I guess in practice, there's always a possibility, particularly in a dilapidations claim, where, as I mentioned during the presentation, the landlord can make the claim for damages without having carried out the works first. So in those circumstances, you've got a claim for damages based on reasonably estimated costs of works, the works that will be required. So you may then successfully pursue that claim, and then carry out the works, but find that actually the works end up not costing as much as you'd estimated. Now, in those circumstances, you are then the landlord will have recovered more than what has ended up being their actual loss. But that's just simply because of what has happened in practice. I mean, the general principle is that you need to establish your loss. Your claim needs to be based on loss, but it's then a question of quantifying that loss. And in circumstances where there aren't actually incurred costs that you can point to, it's based on reasonable estimates. So I think the answer to the question is, in principle, no, because it's compensation for loss. But in practice, it might end up, it may end up being the case that the landlord recovers more than their actual loss.
And I wonder whether another aspect of that, Dan, is the circumstance of a payment clause, where I think sometimes there is that perception that can result in the landlord enjoying a windfall. A couple of the cases that you were talking about, once you delve into the facts, there is perhaps a question about the extent to which works were going to be done. The numbers were quite high by reference to the sorts of properties you were looking at. Yeah. But I think the strict answer again will be, well, the parties have entered into a contract whereby they've agreed a mechanism by which they can assess their loss. And so if you're looking at will the money that the landlord pays out to carry out works to address dilapidations and wants of repair be lower than the amount they recover through through a litigation or a commercial settlement? Well, the answer could be yes, it will be, but on a strict analysis, the question of whether the landlord's loss exceeds what they've actually spent is perhaps a separate question. Excuse me, the light in this room has just gone off. But
well, it is. I mean, in the context, I mean, that's sorry.
When you go down, no, that's fine.
Well, I was going to say, I mean, that was the key effect of a payment clause is that actually loss doesn't come in, isn't really a consideration. It's what loss the landlord ends up suffering is kind of irrelevant. It's contractual payment. So yeah, absolutely. If you've got a payment clause, the landlord could end up with quite a significant windfall because they might recover payment of a significant sum based on the cost of works that they have absolutely no intention of carrying out. But if that's what the parties have provided for, that's what the parties have provided for.
That's the nub of it. I'll maybe take the next one, which is perhaps a little bit, well, it's a bit of both, but the next question: if a break is exercised and there is a time frame and a requirement to provide vacant possession at the break date, can the negotiations go beyond the break date? Well, I think the negotiations can, of course, go on beyond the break date, but I think you need to be crystal clear about the circumstances in which that was happening, because if you have if you've exercised your break and you have the termination date, the issue by reference to that break, then there is a risk that if you stay on beyond that date, that you will be seen to have waived any intention to insist upon exercising the break per the notice that was served previously. So say your break date is the 30th of June and you've served all the requisite notices and so forth, and it's been done as a tactic to see whether a more satisfactory deal with effect from the 1st of July can be put into place, then you definitely run the risk of finding yourself in a situation where, because you haven't vacated by the 1st of July, then subsequent actions beyond the date when you ought to have vacated in accordance with the break notice could come back to bite you. There is an extra layer to the question that talks about circumstances where the termination clause suggests that the lease must go back to shell condition. That, I think, is potentially a significant alarm bell, because there are cases to the effect that if you haven't complied with strict provisions of the lease at the point in time that you seek to exercise the break, your ability to rely upon it might be undermined. So it's perhaps one thing where you're in a position to offer up vacant possession, but agree in clear written terms a slight extension whilst you see whether a new deal can be put in place. But if you get to a point at or beyond the break date where the negotiations conclude and there is no agreed new deal, and you're not then in a position to offer up the premises in the condition they would need to be in order for exercise of the break to remain valid, you could be in a difficult situation. As ever, the precise terms of the lease will be important, but there are cases where a failure to offer up vacant possession at the relevant date has resulted in the break, the exercise of the break being held to be ineffective. So what about the next one? There was a question, Dan, about what's referred to in the question about the commercial reality of enforcing a tenant's repairing obligation during the term of the lease in Scotland. England is difficult to enforce and is usually picked up at the end, although talking about the risk of an insolvent tenant at the end. But maybe just say something briefly about the possibility of enforcing repairing obligations on an ongoing basis during the currency of a lease.
Well, it's certainly something that's possible. You know, the tenant has ongoing repairing obligations throughout the term. They're required, you know, ordinarily they're required to keep premises in a particular condition, and if they're not kept in that condition, or if, for example, specific redecoration clauses are not complied with, well, it's open to a landlord to look to enforce those. I think it would be very unusual for a landlord to have a claim for damages during the term, because you know, at that point in time, what is the landlord's loss? They've got no right to possess the premises until you know, or do anything with the premises really until lease expiry. But it's not out with the realms of possibility. You know, I suppose as it's approaching the end of the term, you know, the landlord might be trying to market the premises for sale, for example, and the condition of the premises might be affecting that, so or preventing that from happening. So I suppose, it's not out with the realms of possibility that there might be a way of quantifying some loss during the lease term. But generally speaking, if a landlord wants to enforce repairing obligations during the lease term, specific implement is the remedy. It's trying to force the tenant to actually do the work that they are required to do. The lease will also, it's worth mentioning that most commercial leases will include a provision entitling the landlord to kind of go in and carry out works if the tenant has been, if the landlord has requested that the tenant carries out works that they're obliged to carry out and the tenant fails to do that. Usually there will be a clause in the lease entitling the landlord to, essentially take possession and carry out the works. So that may be something that the landlord can do as well. But I mean, in terms of the commercial reality, it's unusual for a landlord to look to enforce repairing obligations during terms. Usually something that's dealt with at termination. But as I say, that's not always the case, and there may be good reasons why a landlord might want to do that. If, for example, they want to, as I say, if they're marketing the property and the conditions making that difficult, they want to achieve a quick sale following termination, and they want the works to be carried out, prior to termination. There may well be commercial circumstances where that is what a landlord wants to do.
The next one is, you can take a couple of questions together. There's a question about whether dilapidations can be served following termination of the lease, and is there a time limit to submit a dilapidations claim? So taking them together, it will depend on the terms of your lease. It's important to be wary of the fact that sometimes there is express provision for the timing within which schedules of dilapidations, particularly terminal schedules of dilapidations, need to be served either pre-lease end or within a period of time after a lease has come to an end. And I have seen parties fall foul of provisions of that sort in the past. So always look out for them. But in the absence of a provision, then you would have a little bit of time post-termination to serve your schedule. In the context of a commercial lease, I think the law and prescription would come into force. And so you would probably, if you hadn't done it within a period of 5 years from the termination of the lease, then you would likely to be facing a claim that has prescribed and is therefore no longer available to you. But I cannot think of any circumstance I've ever dealt with where you've looked at that sort of time period. That dilaps tend to be done in the run up to lease end for reasons that many of the participants, I'm sure, will be very familiar with, or shortly thereafter. The Tonsley case, Dan, I think, as I recall, was an interesting one. We weren't involved, but you could infer from the circumstances that that was one that was pursued quite actively 2 years or so from memory after the lease had come to an end. And the inference seemed to be that they'd seen the ATSIP decision, looked back at exactly what their lease said, realized they had similarly worded provisions, and successfully pursued the argument that they did thereafter. So there's an example of something that was a decent way on from the end of the lease, and it was still open to them to do that. But as with all of these things, it's always a good idea to crack on sooner rather than later. And I think we've possibly got time for one more. Maybe this is from Douglas Aiken. Does the principle of notice informality accepted for tacit relocation apply to breakout option or other lease notices? It's really just for excluding the operation of tacit relocation. It's perhaps important to draw the distinction as far as break notices are concerned. You'll have a contractual provision. What you need to do is comply with the contractual provision, and that typically will involve the service of a notice in a particular form, within a particular period of time and so forth. So generally speaking, you will have a clear requirement that you need to comply with to effectively operate a break provision. The tacit relocation issues that I was talking about earlier are just perhaps a slightly odd development of the law over time, but very much relate to those particular circumstances and what needs to be done to exclude the operation of tacit relocation. Dan, anything you want to add to that?
No, just I guess with break notices, it's very, very important that you do operate strictly in accordance with the lease.
Don't leave it to the last minute.
No.
Make sure you do exactly what Dan said and pay very close attention to the lease provisions. And coming back to the question we talked about earlier on, the fact that it's important to pay very careful attention to whether there are other requirements, for example, the offering of vacant possession, the stripping out of the premises, so forth, that you need to have complied with before you get to the break date. Okay, well, I'm sorry that there's a few questions that we haven't quite managed to cover. I'm extremely grateful to everybody who's either submitted questions as we've gone along this morning or who submitted questions in advance. I hope the answers that we have been able to give over the last 15 minutes or so have been useful, and I hope that the presentations as a whole have covered some interesting ground so far as you're all concerned. So it just remains to say thank you very much for signing up and for joining in, and we'll be in touch in due course when we run the next of our property dispute resolution group seminars. So from Dan and from me and the team here, thank you very much and enjoy the rest of your day. Thank you.